I will kick us. Got it. All right. Welcome, everybody, to the representing minors in guardianship proceedings. Really happy to do this. This has been a work in progress, something that Lara and I have been talking about doing for at least 15 years. And so we are just giddy to get this up and going and being able to present something for you that can accomplish two things. One, train people on how to represent minors and guardianships, and also get some MCLE credits for representing minors and guardianships, because it can be elusive and it can be daunting for many people throughout the year. And so some of the things that we're going to be discussing here, as you can see from the slides, why probate court? We're going to go over the basics of guardianship principles. I'm appointed. What now? How do you qualify for court appointments? And what does the court expect? And why on earth did I agree to this? So that's really the general overview of this. And so to kick this off with a little bit of the history of why the probate court, Lara, do you want to start leading this into so a little bit about us? Both Lara and I have been practicing in this area of law for several years, and accepting these court-appointed cases for many years through the conflicts program. And we both find this to be very, very rewarding work. And it is something that is a hybrid of family law, probate law, and everything in between. You'll see from the slides how we have taken, and that it is really a function, a bit of dysfunction, and it's excitement all in between. Some of the conversations you have, you get to experience something that you've never experienced before. It's like Disneyland in the courtroom. So so Lara, why don't you take us away and tell us why the probate court? One more thing. If you have questions, please put them in the chat as we go. We will answer questions as we go. We're putting kind of the guts of this in the early portion, and a lot of the law towards the end. So we don't want to miss out on some of the questions that you might have. Sorry, Lara, go.
Okay, so yes, as Oliver said, he and I have been doing this. We started out working at the same firm doing guardianship cases together. So we both have a real passion for it. And it is weird when you start out, why would probate court handle child custody? And the reason is because it used to be that children were considered property, and they were divided up when parents passed away, just like the property was. And probate court was in charge of that. And now, because we have so many situations where parental custody becomes problematic with drugs and other situations that have cropped up over the years, the probate court has taken on more and more of these cases. So, and you'll notice that we have random pictures of famous people in this presentation. And if you see a famous person, it means that they were either in the foster system or that they were the subject or party to a guardianship proceeding. So there are three courts that handle child custody. There's family court, there's dependency court, which is when Child Protective Services is involved, and there's probate court. And I'm going to flash through these quickly, and you will have the materials so that if you need to look something up, you'll be able to. One of the biggest issues with having probate court be involved is that in family court, usually everybody has an attorney. People are familiar with divorces, and parents often have attorneys. The court will appoint attorneys for the children in family court. Sometimes the court will appoint attorneys for parents. And in probate court, the only person who gets a court-appointed attorney is the minor, unless the parent is a minor, which happens from time to time. But the way that probate court custody works is that if there's a custody dispute between two non-parents or one parent and a non-parent, you end up in probate court unless Child and Family Services has gotten involved.
So Lara, it looks like just a statement here in the chat, understanding that guardianship court trumps family court and family court action is stayed. Is that true?
Yes. Yeah, the hierarchy, the court that is the most important, I think, in determining child custody is dependency court. Those are the 300 cases. Those are cases when an outside agency, Child Protective Services, has made a determination that parental custody is harmful. And at that point, all the parties get their own attorneys appointed, there are social service options, and that is sort of the highest ranking. So if there's a guardianship case or there's a family law case and allegations of child abuse come up and CFS gets involved, then whatever decisions that court makes will trump family court and trump probate court. And between probate court and family court, it kind of depends. Usually probate court trumps family court. Sometimes they kind of go side by side. Have you had that experience, Oliver?
I have. In those cases, if there's a family law proceeding, that is going at the same time, the probate judge may say, well, we want conclusion to occur there. And that's if the parents are in a matter in the family court and that needs to be resolved. So it could be something that is happening that's very close and it's just hasn't been determined yet. So there are some close calls that can occur. But there's a question also about whether the probate court and the juvenile court can have dual jurisdiction. And so generally generally no. It's usually the juvenile dependency court is going to take the jurisdiction. And there are some instances because they do have permanent plans in the dependency courts, and in the dependency courts they are going to offer services, and they're going to take additional actions and assist the families in reunification plans. The probate court doesn't offer those. And so there's a great disparity there on what is going to be offered to the family. And so they want that type of separation. This isn't to say that CFS will not say we're not going to take this and there will be no action, leave it in the probate court before it even gets to a juvenile dependency proceeding. But usually it's not going to, there will not be a dual jurisdiction occurrence.
I would say guardianship cases are kind of like the hot potatoes of custody cases. Kind of nobody wants them. In family court, if there's an issue and parental unfitness is an issue, then grandparents might get involved, and particularly grandparents who are having trouble getting visitation orders, they may file in guardianship, and family court is happy to say, yes, probate court, you take over. And Child Protective Services often will try its hardest to not take custody cases if there's any reasonable adult who might be a good option for custody. Often Child and Family Services will push that person, whether it's a grandparent, aunt, uncle, neighbor. They'll say, oh, you know what, we won't open a case. Why don't you guys here's your paperwork. Why don't you go to probate court and you can avoid foster care by doing this route. And then often probate court, if there are allegations of any kind of abuse, neglect, or drug use, probate court will say, I don't know, maybe this should be a dependency case. So let's do a referral to CFS. So there's a lot of ping ponging. And like I said, it's kind of like hot potato.
Yeah, I agree. So let's talk some basic guardianship principles.
Okay, it's not letting me. Oh, okay.
There you go.
So issue spotting. Oliver, you want to take this?
Yes, yeah. So one of the first ones that we're looking at, Lara mentioned this earlier, that we see a lot of illegal drug use. And this comes up a lot more frequently than you might think, that for the initiation of these proceedings, perhaps a grandparent or a well-meaning adult will say, we have to get these kids out of this situation because the parents are on drugs. And so it starts there. And then it moves on. Another instance is domestic violence. Courts take this very, very seriously, and they should, because there's many, many levels of domestic violence that just permeate throughout the households. And it's, as minors counsel, once you're inside there, you start to, you can feel it almost oozing in some instances, just how toxic some of the households are. And having the kids out of there, it can be just a great thing to happen. But sometimes you're moving them into just sometimes to toxic households too. But getting them out of that,
and into the fire.
yes, it does occur. But so those are really the big ones. And so the appointment considerations here. There's a question: do relatives, aunts, uncles, cousins have visitation rights in guardianship cases? Excellent questions, because guardianships can tend to be like the Wild West when it comes to visitation. Interested parties can apply for visitation. And many times it can be granted if there's a substantial relationship that they might have had, or any type of relationship. They can say, I would like to have visitation. And the court will listen to those requests, won't necessarily grant it, but they can apply for that request. Similar to under the family code, family members can apply for visitation with children, even so long as there's some sort of existing relationship. And people don't like it.
I think probate court is also sometimes used as kind of a workaround, because in family court, it can be very challenging for anybody other than the parents to get visitation rights. And I do believe that some petitioners in guardianship cases, maybe step parents, maybe grandparents, they're really filing in guardianship court because they want a visitation order. And like Oliver said, it's kind of the Wild West. Now we've put up these rules and statutes that are relevant in family law cases and that show situations when minors counsel would be appointed. And we just think that it's important to keep these kind of tenets in mind, that all three courts share a philosophy that the minors counsel in these custody cases are going to be the eyes and ears of the court. And so much like a guardian ad litem. So
a lot of it comes down to that number 7 there. The best interest of the child appears to require independent representation. That's where most of the courts will fall on whether or not an attorney should be appointed. It's certainly in the guardianship courts. That's what we see a lot of.
Yeah. And then in probate, the most controlling factors and the things that you want to keep in mind in these guardianship cases is that in order to justify or support a guardianship, the court needs to be convinced that it's necessary or convenient, that parental custody would be detrimental to the minor, and that granting the petition would be in the minor's best interest. And it's a hybrid of the probate code and the family code. So family code gives some indications to you about what factors the court will be looking at in terms of trying to figure out if there needs to be a change in custody. And one thing that's really important to remember, in family court and in other places, you go very hard against the parents. Sometimes these cases get very contentious and nasty, but in probate court and under this code, in the pleadings, you are not to talk about why parental custody is detrimental to a child. You need to focus in your pleadings about what is best for the child, not on slamming the parents.
Question, probate jurisdiction extends to visitation, but court cannot order parental drug treatment, DV treatment, and the like. Is that true? The court can order drug testing. The standard testing, I believe, is urinalysis, but nothing more extreme than that. Cannot order drug treatment, cannot order any type of domestic violence, battery or intervention or anything like that. Can make the suggestions, the parents can follow that, but that would fall under the category of doing any type of reunifications and parental reunification, and that is not permitted in guardianships.
Yeah, and so something to think about when you're appointed as minors counsel is, without these services being provided, one of the services you can provide as minors counsel is to encourage family members to seek out various programs, to voluntarily agree to various things once you can convince them that
I never got on those.
advocating. Oh, Catherine, your speaker. You need to, once you get appointed and you get some rapport going with the parties, then you can start to almost wear a social worker hat and try to get the parties treatment they need to support your client.
But really fast, when it comes to granting a guardianship, it's clear and convincing evidence. So it's a very high burden of proof. And also the detriment to the child, it includes removal from a safe, stable placement that a child has maintained for a substantial period of time. Now, this can be quite controversial in guardianship circles, because that could be if the child has remained in a temporary guardianship for a long period of time. Sometimes the temporary guardianship will be granted early on, and we don't get to a trial for a year and or 9 months later. And then the argument can be made that they've now been in a safe, stable placement for a substantial period of time. And then we have a shifting of the burden of proof that you're removing that child from that safe, stable placement.
Yeah, and then it becomes
the preponderance of the evidence.
Yes. So again, we have all these code sections that you'll get in your materials. So we're not going to go into total detail, but one of the issues with representing a minor is that you often are representing someone who can't really be asked their opinion, or who can't speak if the minor is a baby. And so how do you figure out at what point you are supposed to be the child's mouthpiece? And that's sort of what we're talking about. I think it's always, if you have a client who can express a preference, I do think it's incumbent upon you to advise the court. But this is unlike in conservatorships. I know that many of you are conservatorship practitioners, and when you're representing a conservatee, you advocate for what your client says they want. In representing children, it's not that clear. Everything is mushy and fuzzy, and you are really supposed to be playing a hybrid role of guardian ad litem and advocate. You need to let the court know what the child wants, but the court is also counting on you to help them understand what's in the child's best interest. And so there's no magic age, but if the child can express to you what they want, part of your duty is to let the court know. Now, there's 14 years old. If the client is 14 years old and they say, I want to talk to the judge, You need to make that happen. That's part of your job. That doesn't mean that everyone who's 14 and over has to. And that doesn't mean that a 12-year-old who wants to go on the stand can't, but it does put an obligation on you. If the child is over 14 and says they want to take the stand, you need to facilitate that. And having a child talk in the courtroom in front of the parents is not usually a good idea. I've had older clients testify and want the other parties to hear what they have to say, but that's very unusual. And often the court will hold an in-camera proceeding with minors counsel, the minor, and the judge to talk informally about what the child wants so that the court can get a better sense of what is in the child's best interest.
I'll frequently have people say, you need to have this kid testify. I want my kid to testify. The grandparents say, I want the kid to testify. Like, I don't think you guys do, either of you, because frequently kids will say things to please whoever they're living with or whoever they're with at the same time. And so it'll conflict, and then you won't even know the truth of who they really want to be with or what they want to do. They're just in a land of confusion, and that's really not the best for anyone. And the answers they're going to give the judge, who knows what they're going to say. They're going to be nervous wrecks. Even talking to a judge is going to be very nerve-wracking for them. Is that really what's best for them? Even a 14-year-old? Is that, I know talking to a judge, the first time I talked to a judge as an attorney, I was very nervous. Tell me a 14-year-old's going to be fine doing that? Good grief.
Yeah, usually the kids who want to talk are the kids who are getting most heavily coached. That's just how it is. So, you have a very tricky balancing act to do. And just to be clear, often when the child speaks to the judge isn't going to ask ultimate questions of where do you want to be? And also neither will you as minors counsel. What you're going to do and what the judge will do is just kind of try to get to know the child a little bit. What's making the child happy right now? What are the child's concerns? How do they feel about school? All of those things can help you come to conclusions about best interest without putting the minor in the uncomfortable spot of having to make a choice or even say out loud what they would prefer. So how do you qualify for court appointment? We're going to zip through these, but the probate code has rules about who can represent minors. So does the family code. And if you're in Contra Costa County and you want to represent minors in guardianship cases, you want to reach out to this lovely woman, Oksana, through the conflict program and apply to be minors counsel.
We might have the rates wrong on there. So you can discard, you can ignore that.
Okay.
But yeah, but that's fine. That's still the right person to contact.
Is this the right, all services 154 an hour?
147.
147.
All right. Sorry.
It's gonna go up next year and the year after.
So something to look forward to is
Yes.
what we want, to eager anticipation. That's why we put that number.
That's right. Thank you.
Yeah. So every year when you're representing minors, you need to file something with the court saying that you've taken the requisite classes and that you have the requisite insurance. And mentorship is a big thing. If you are interested in working with minors and you don't have the experience that the code requires, which is, I think, 3 trials, and it's a pretty heavy amount of experience for 3 cases. So you can connect with me or Oliver or any of the other experienced guardianship attorneys that are already on the panel and have them mentor you and be your resource for questions. And the conflicts program may well allow you to get involved.
There is a mentoring program now that the program offers, and you could contact Oksana and she could put you in touch with the appropriate mentor. So that there is now a process for that as well, Lara. So
Oh, thank you.
yes, no problem.
Thanks.
You
Yes,
should know that.
we got a lot going on today. Don't worry.
Yeah. Okay, so things you want to think about is taking classes on child development, looking for risk factors of child abuse and neglect and family violence. Those are good things to know about when you're representing minors in guardianship.
Those are, and just to dovetail on that, you can never learn too much about those. And Commissioner Don Green used to tout that regularly about picking up additional materials on early childhood development as well, just to learn more. The more you know about children, the better it is. And I'm always trying to learn as much as possible. And so I'm a huge fan of that, big proponent.
You have to be in good standing with the bar in order to represent children.
Yep.
You can't be Michael Avenatti. Okay. So I'm appointed. Now what?
What do you do?
I mean, we were talking about how children and attorneys are nervous before talking to judges, but it can be nerve-wracking going into a house and talking to children. So I kind of have
just a really quick statement that was in the chat. A member wrote an article in the CCCBA magazine about court-appointed counsel and implicit bias. It's definitely worth mentioning. If you are interested in being court-appointed counsel, that it is imperative that you do research and review on implicit bias, because anytime you're entering into somebody's home, you are going into a completely different atmosphere than you are normally accustomed, unless you live there. And so there are different cultural norms, different religious practices. So the more you know, the much better it is. I recommend picking up that article. Hopefully we can find a link for that from the person that submitted that in the chat.
Yes, and I look back sometimes at my earlier cases and I kind of cringe thinking about some of my own implicit biases, and it's really important to be aware. Because I know that in some cultures, for example, it is very common, like if there's one family member who struggles to get pregnant, some cultures really feel comfortable almost sharing children and sharing kids. And they may say, well, actually, I'm the parent, but really my sister had the baby. And it gets very confusing. And if you don't take into account that you're looking through a particular lens, it can affect the recommendations that you make to the court. And I know even things like how long a child sleeps in the room of a parent. Before I had kids, I was so creeped out by the idea of children sleeping in the same bed as a guardian or as a parent, when I had no concept that sometimes you just there's reasons, financial reasons, and there's also emotional reasons that you just have to be aware of your own biases.
Yes. So on this one, I love this slide as far as explaining to the minor your role. One of my favorite things is the introduction to myself, to my client. And I always like to say, hi, I'm Oliver, and I'm your lawyer. And they usually stare at me blankly, no matter the age. And I'll say, have you ever had a lawyer before? And usually they're 5, 6 years old, could be a teenager, and they'll say no. I'm like, you've got one now. This is awesome. And we just go from there. And sometimes they'll continue to stare at me blankly because they have no idea what's going on, but they know that something is going on. And I like to try to make them as comfortable as possible because they are in a very uncomfortable moment in their life. And that is how I always try to approach this situation. that you are a stranger coming in their life is in shambles, or it was in shambles and now it's getting reconstructed. And so the more stability they have there, the better. If you're just some kind of weird person coming in and handing them a business card, it's going to seem even more awkward. So
yeah, I usually do a pretty standard spiel that I've kind of laid out here, where I say, part of my job is to talk to the judge about if you have certain things you want the judge to know, I can do that. But also part of my job is to make my own recommendations. And I tell them that so they know that the pressure isn't all on them and what they say to me, because most of the kids are going to be getting pressured by the proposed guardian and their parent. Tell your lawyer this, tell your lawyer you want that. So I always, if the child's old enough to understand, if I have like a tween or a teenager, I will say, let me be the bad guy. Everything you tell me is confidential, and I can only share what you tell me if you want me to. And otherwise, what I tell the court is just going to be, this is what I think. So I can be the bad guy, and you can, if you feel a certain way and you feel uncomfortable telling anyone, you can let me know, and it'll be private between us. And I can be the one I can tell your parents, I don't think you should be there. Or I can tell your grandparents, I think that the child should be with their parents. Like I found a lot of success in building trust that way.
yeah, and you got to build it. You got to get comfortable with them, and because they're going to be in a very uncomfortable moment. And so just I like asking them, why do you think I'm here? And a lot of times they'll say, I don't know. I say, well, there's this court thing going on. Do you have questions about it? Do you know anything about it? I've heard talk. Like, oh, okay, what have you heard? I always like to ask them questions about what they've heard and let them talk. And they like, well, what's going on with them? And usually they'll start opening up. I've got a few little things that I do. I like to sit down and just hang out. And the more time that I spend with them hanging out, I know Lara's a big fan of taking kids out to ice cream and getting them away from the house. I like sitting in their rooms or sitting around playing video games with them and just and hanging out like that, and just developing a rapport with them, because I'm really good at beating kids at video games, and I like to exert my dominance in video games. No, I'm not very good.
Well, Oliver, any kid who gets Oliver appointed as their attorney is very lucky, because Oliver is naturally very easy with kids, and he's a magician. So like not all of us can pull a rabbit out of a hat when we first meet our kids, but he can.
I can teach a card trick.
So I rely on ice cream and food, other treats. And I do I agree with Oliver that my first meeting, I try to talk as little as possible and just get to know them. And like Oliver said, say, I know you know that there's a lot of people who love you and want you to live with them. And I'm here to help you with that. But for now, show me your room, or do you want to go get ice cream, or whatever it is. I usually spend the first session just building some rapport.
There's a question in the chat about home visits versus doing a Zoom visit. Is that acceptable? And yes, you can meet with somebody on Zoom. It's certainly not preferred. And as I say that, there's a kid I'm going to have to meet on Zoom because I'm just not able to get up to meet him because of the distance. And that's exactly the question. And so certainly I would rather there'd be in-person meeting, but I found too that sometimes kids will get chatty on Zoom, but not nowadays, more so. But you can't really beat in-person contact.
And I have a good cautionary tale.
Oh gosh, yes, yes.
Yeah. So I had a case where my client was 13 and it kind of looked like a no-brainer. Tragically, his father had died. And when his father died, he was living with his stepmother and father in one house. And he had an aunt and uncle who were petitioning for custody. And the stepmother also petitioned for custody. And the child was very articulate and was very clear. I'm very happy living with my stepmom. I want to stay with my stepmom. I don't really know my aunt and uncle that well. And the father had nominated the aunt and uncle to be guardians. So they had a strong claim and they were very stable. But the child, again, was very clear. I'm at my school. I'm happy. And I went to meet him. And he met me outside of the house with the stepmom. And I did my usual spiel of like taking him out to eat. And we got burgers and spoke. So I saw the outside of the house and met the stepmom and everything seemed great. And the child was very talkative and very engaged and had a million reasons why he wanted to stay with his stepmom.
Sounds perfect.
But then the aunt and uncle kept telling me, I really think the stepmom's not stable. I really think you need to go again. I think there must be something you're missing. And I hadn't gone in the house. So I decided to do an unannounced visit. I announced to my client that I was coming, but I didn't announce to the stepmom. And I showed up and the child proudly let me into the house, which was a very modest 2-bedroom house or apartment. And when we walked in, it was like a hoarder house. There was dirty food everywhere, like just awful, cigarette smoke everywhere. And there were many dogs, pit bulls, who my client was clearly terrified of. Like he was hiding behind me. And in the living room, there was almost like a tent. And there was a baby and a mother who were living in the living room. And then
Hold on, Lara. They were living in the living room in a tent. So it's as if they had their own room in the house in a tent.
Yeah.
Okay. I just want to track the story.
Yeah, but the dogs belonged to the tent people.
Right.
And then when I went into the child's room, his 16-year-old stepbrother was like half naked in the bed that they share with giant computer screens all around. And it was a nightmare. And I took the child out afterwards and I said, that feels like a very chaotic place to live. And we talked more and he still wanted to stay there, but eventually I had to go against my client's wishes and advocate. I felt that there were so many dangers in that house and that the child just didn't know any different. And that child is now 19, and I have spoken to him afterward. And he was so angry with me when I recommended to the court that he live with his aunt and uncle. He wouldn't speak to me anymore after that. But then after he turned 18 and we spoke again, he said that it was the best thing for him and that he sees in hindsight that he really needed to be out of that chaotic.
So Lara, so initially you advocated for your client to stay there, then you changed your position and advocated against him, and you made this representation to the court?
Yes, and I wrote a very detailed report because, and we'll kind of get into this, but the court investigator is the one who does the investigation and makes a recommendation to the court. I think in that case, the court investigator had been to the house, but because they always schedule the visits, they don't typically do unannounced visits, they got a really different picture than what I got. And so that's why you just kind of need to be aware and look for the signs. I did you got to listen to everybody, and it's
You
very-
have to. And you might not like listening to everybody because everybody's going to have their stories and some of them are bad, and you'll show up sometimes and everything looks fine, but then other times it looks terrible, just like Lara said. And gosh, I've sat down on couches and there's been substances that I'd rather not have sat on. It's like, oh gosh, you knew I was coming. You could have cleaned a little bit, but that's the reality. That is not a good sales pitch for becoming minors counsels. Just disregard that story.
Yeah, sometimes I bring someone with me, depending on the allegations. I've gotten a lot of cases recently where there are allegations of parents like wielding guns in the house and the child being afraid. And maybe in those cases, I'll start with a Zoom meeting. So let's see. Just keep in mind the trauma that the child has been through. Always be sensitive to that.
Yeah, and teenagers can be back and forth, just like in Lara's story too, that what they say today, they could flip. I was on a case, and I think Costa's on here, and what the minors I was representing, they were back and forth with the mother, and my clients were with the grandparents, and then they want to go back, and then back and forth. It was like a ping pong ball, and I'm throwing my hands up in the air and saying, teenagers, what are you? They are just an enigma, and I want to advocate the best I can, but at the same time, you have to recognize that their minds are spinning, and there's so much going on. And if there's additional trauma, if they've lost a parent, then it just makes matters worse. And you don't know what's going on elsewhere as well. This is just one small snapshot of their lives that we're getting to see here too. And their world is much bigger. So, sorry.
And there is a statute that specifically says that you do not have to be a social worker. You're an advocate, you are an attorney, but always remember that at the end of the day, you are a counselor at law. And you, in guardianship cases, you may be the only adult who has no skin in the game, who has no dog in the fight, and who can really weigh in about the best interests of the minor.
Yeah, you might be the only person that they trust in this entire situation. So it becomes a really tremendous responsibility from that regard. And I've had kids who have kept in touch with me, and they're now in their late 20s, and which is kind of awkward because I'm not that old. And but they still have maintained that trust in me, where they've come to me advice after they've reached the age of majority. And it's very flattering, and I love that role that I've stepped into here.
Can I jump in for just one moment?
Yes.
And that's to say, so with the Attorney Support Division, we now have social workers, which are also available to Guardianship Counsel. So in cases where you are concerned about, going to the house or need extra support, extra services, somebody else to interview family members, you have that ability to petition for a social worker to be appointed on the case, on the court-appointed case, and to have extra services. So I think that's really should be helpful to attorneys, and that's brand new.
Thank you, Oksana. And one of the things that you're doing as minors counsel, you, like I was saying before, you are, along with the court investigator, the eyes and ears of the court. And so I know that our judges in Contra Costa County, they love a written report, and it can be very helpful for the parties, and it can be very helpful for counsel if you're in one of the rare cases where all the parties are represented. I am loath to do written reports most of the time, because I feel like my best skills as minors counsel is to bond with all the parties, but not everybody does that. But I really like to get to know the parents. I really like to get in there with guardians. And I have found that when I put something in writing, it really tends to betray the trust. You have to take it on a case-by-case basis, but just be aware that what you put in writing is part of the public record, and the kids can look at it later and the parents can look at it. And if you're trying to mend fences and heal divisions within a family because that's what's best for your client, you just have to tread lightly when you're writing your reports of counsel. And so, the things that I think are good to highlight if you're doing a written report is you give a little factual background that you glean from talking to the parties, try to keep that neutral. You put in your recommendations, you list your contacts and your observations from your contacts. If you want to be subtle about what you're seeing and not give a particular recommendation, and then you can make an ultimate recommendation to the court. I often find that my time with the family is best spent trying to work out agreements. I do a lot of informal mediations when I have all pro pers and a child, and I think there's any chance of helping the parties work together. I am a big fan of setting up meetings and trying to talk and coming up with contracts that people can understand and relate to.
And I concur when it comes to the reports. I used to put in reports all the time, and I still do, because the judges, but they're not as detailed as they used to be. They'll have information in them, but I'm sparse on my recommendations. And what I found is that my opinions tend to change over time as I get to know the parties, as more and more information comes out, as the court investigators make their reports. I'll find out more information about the parties. You see their history. She'll say, oh, good gosh, am I really recommending that party? So you want to be careful about that. And so there's just some little things in there that you just want to, I like to just pepper it on in there. And the judge will sometimes say, do you want to make a recommendation? I'll say, I want to reserve any recommendations at this time, because I'm just not ready to. You make that commitment, you're drawing a line in the sand. And if you start changing your recommendations again and again, then the judge is going to say, what are you doing? And so I'm always just hesitant to do that. I'll let you know let the court know what's going on in the matter. But at the same time, I'm just very hesitant to do that. And I know some people will put that out there. And again, I think it just creates too much of a commitment to one side or the other. And that's not really fair to my client when I'm doing that, because there's too many moving parts in these things, and it doesn't necessarily leave as much room as, like Lara was saying, to help the parties move things along and maybe mediate some sort of agreements to where things could resolve amicably.
So we talked about child testimony. We wanted you to have all the information if you decide you want to engage in having the minor testify. It's pretty rare. Just keep in mind that one of your jobs is to protect the minor from further trauma. And it's good to remember that, and you can help parents and guardians understand this too, that the judge may conclude that anyone who puts a child on the stand or really wants to may be more interested in winning than in what's best for the minor.
And sometimes the judges will want to talk to them. The past couple trials I've had, the minors have not testified. It's probably been over maybe 2 years since I've had a minor testify, and they did it in chambers and just with the judge. Judge said, well, I just want to talk to them. That's it. I don't want to talk to anybody else. You guys scram. Like, all right, good enough for me. I was fine with that.
And we talked about the de facto parent situation. You know, if a parent has disappeared and the minor has been living with the proposed or regular guardian for years at a time, and now parent is stable and has come back and is saying, I'm ready. We need to be mindful that the standard of proof shifts, the burden of proof shifts, and there's a presumption that removing a minor from a safe and stable placement is detrimental.
And I am only bothered when the temporary guardianship lasts so long that somebody is considered a de facto parent. I think that is utterly ridiculous and should not be the case.
And yeah, it's a problem.
It is a problem.
It's
Should
a
not be.
very flawed system that we're working with. And that's why your role is so important and why it's such challenging and rewarding work, because there are so many, it's just so imperfect.
Yes.
But your impact can be powerful. These are just the dependency guidelines, which are good to keep in mind, that you want to ascertain facts, you want to prepare for trial. These are all the duties that you have as minors counsel. Make recommendations from time to time, or you could request a guardian ad litem. Sometimes in the guardianship of estate cases, that might be an issue, having a separate guardian ad litem to protect the money. We talked about the minor's wishes.
Mhm.
Okay, I know that there are a lot of estate planners here. Something to keep in mind, a lot of times people think that if in their power of attorney documents they nominated a guardian, that person is going to be the guardian. Just a reminder, that is just one piece of evidence. And if I think back to when I did my own estate plan with my children being babies, I recommended certain family members that we literally haven't seen now for 6 years. So I would no longer want them to be the guardian, and I haven't updated it. Just keep in mind that nominating a guardian in your estate plan is not the end all be all. It's just one more brick in the wall. Children don't always get counsel appointed in guardianships. If you are representing a parent in a guardianship, or you're representing a grandparent or proposed guardian, I highly recommend that at the outset of your case, you request the appointment of minors counsel. What does the court expect of me? Here are our lovely judges. We talked about mandated appointments in conservatorships and the role in conservators. In conservatorship cases, it's very different. In custody cases, it's discretionary for the judge. So the judge expects you to meet regularly. The judge expects you will often be the only lawyer involved in the custody case. If that is the case, it's up to you to prepare for trial. It's up to you to put on the witnesses. And it's up to you to keep abreast of the child's needs throughout the pendency of your appointment. Do you want to talk about the investigator?
Oh, sure. Yeah. So we've got the court investigators. It's if you don't hear from them, it's a good idea to reach out to them, and they have to do a report that's has to be considered by the judge, and it's going to be generally thorough. In our county, thorough. Not all counties put the same level of effort into it, but Contra Costa does a great job. And our investigators, they look into everything, and we're very fortunate here.
Yeah.
And one thing to keep in mind too, as the matter progresses, that they are an investigator. So if the matter is going to be going to trial, that you want to prepare to call them as a witness to get any information in and have their testimony. So that's something that you have to prepare for as you move along. You're going to be treating this case just like you would any other case, but that because they're going to gather, they're going to be able to do many of the background checks that you will not have just at your disposal regarding the history of the family members, the prior, not just criminal history, but prior interactions with children and family services, that you'll be able to, you won't have access to all of the children and family service reports, but you'll be able to ask questions to them about those and about their impressions and the like as you come to trial.
And as Oliver was saying, these are very fluid cases. It's easy for our opinions as attorneys for the minors to change. So these cases can be hard. It's really hard to know what's best for the children. And it is a great resource to be able to pick up the phone and talk to the court investigator and really kind of talk through your concerns, because two heads are better than one.
Absolutely. And let's see.
We talked about requesting
A phone. Yep, talked about this already. And
when does
when does this end? When does it end? Yeah.
So you can be relieved by the court. It ends by operation of law when the minor turns 18. You can ask to be relieved when something is settled, but because guardianship orders can be modified at any time, just like a custody order, and because the families may continue to fight until the child turns 18, I often ask to stay on. And if I've done my job right and formed a bond with the client, I want to stay on until it ends.
I'm the same way. I've got a ton of cases that I'm still on. I know it drives the conflicts program crazy of all the open cases that I have, but some things pop up on these cases more so than any others. I've got cases that have been dormant for years that I'll get a call out of the blue and say, hey, we've got a question. This is going on. Is this something we should talk to you about? Like, oh yeah, something maybe about 6 months ago you should have talked to me about. And if that happens, it may have fallen off the radar with conflicts. And what you do is you just call them and say, hey, can this be reinstated? And usually it's not a problem if you're still on the case. Also, you could be relieved, and the reappointment is possible as well. But staying on the case, I don't think is really too detrimental. I think checking in with the families is good as well, just to make sure that everything is okay, because again, things can kind of go awry.
Yep.
Oliver, if I can
Yes.
jump in. So, the laws have changed about the juvenile cases. And so now even in juvenile delinquency, we keep them open until the kid is 25. So I think it's totally appropriate for guardianship cases to stay open until the kid is 18. Just a different analysis at this time. So that's why I'm not upset about you having dormant cases. And when you're dealing with children, I think it's the best care if you keep it open. Now, if they have aged out, if they're 18, or if you don't think that you will be needed, that we do ask you to close the case. Again, if you have to reopen, we will reopen. But yeah, I'm totally fine with keeping them open too. Okay.
And just a note, if there's a guardianship estate involved, if there's money involved, there are accountings that are due. Guardianships of the estate stay open beyond the child's 18th birthday.
Okay.
Usually have about a year grace period. And then for some of the juvenile, for some of the immigration guardianships, which we're not really talking about today, but we'll happily talk to you about online, it can extend beyond the child's 18th birthday.
And we do handle immigration juvenile 300s, and those stay really up until you deal with their immigration status, sometimes beyond 21. So yeah, that's true. So if you have a question about what to do, just email me or call me and we'll figure it out.
Well, that's great.
So you're doing your job right if everyone's mad at you. Everyone should be mad at you because everybody has a dog in the fight. Everybody has a perspective and everybody is passionate about it. I mean, listen, nobody goes to guardian court if they feel guardianship cases, if they feel ambivalent about it. The people involved are passionate. They feel very strongly that the child needs them, or the child needs something, or the child is in some kind of danger or harm. So tensions are very high.
You'll know you have arrived when you hear from each side, usually in the same day. You are not listening to what the minor wants.
Yeah.
And when they both say that, you're like, this is it. This is that shining moment that Oliver and Lara were mentioning, that everybody is officially angry at me within the same day, saying that I am not listening to the minor tell me that they are not, I'm not advocating for their position. This is awesome.
Yes.
Arrival.
So you're doing your job right. And there are people like to complain about minors counsel, and there is a way to do that with through the local rules of court.
Yes.
Okay, we've talked about balancing interests.
Mhm.
Again, always keep in mind those buzzwords: minor's best interest and parental custody detrimental. So what does detrimental even mean? I mean, Child Protective Services said everything's fine, but we've still got a child telling us, I don't want to go with mom, I don't feel safe. Or the flip side is, I don't want to be in this guardianship anymore, I don't feel safe. So how do we deal with all the people? Keep the lines of communication open as much as you can. Talk to the allegedly bad parents, talk to the guardians, try to broker meetings, use the mediation. You get 3 hours free with our wonderful mediators. Use a mediation, use another mediation. I am a big fan of minors counsel participating in mediation. You can be a huge help. It's all about turning down the heat. And if you can convince parents that, look, your child is really safe and really happy, and look at what they're doing. And if you want to have a relationship, stop fighting and get the counseling you need, or stop fighting and do this. It's temporary. You're gonna, if you want to have a lifetime relationship, please keep working with us. So be respectful, kind, and attentive to the pro-pers as much as you can. It's hard, it's a time suck, but it's worth it because everyone has a point of view, and these are such important decisions for the child that you're charged with representing. So why do it?
Why do it? Compassion, because you're not doing it for the money. You're not going to make big bucks doing this. And one of my dear friends, she refers to this as low bono work, and I love that because you are doing a tremendous service for the community. You are helping families. You are helping the community become a better place. And that's how I look at this. Anytime I'm going out to somebody's house, anytime I'm going to court to help these families, I'm helping myself. I'm helping my friends here to make the community a better place. I'm helping their family make their family a better place. And I know this because that's the feedback I get. And when you see when I see my clients graduate high school, and when I see them create their families, and I see them doing those activities with their families, I know that things are working. And really putting myself in their shoes and being empathetic at all, no matter what, I know that it's worth it. So that's why I do it. And it's just a sense of accomplishment when things are well. Even sometimes parents will yell at me, and they just yesterday, somebody was yelling at me. It just happens. And I try not, I don't take it too personally because they're going to. And that's because they're frustrated with what's happening in their life, or they've got other issues. And I just have to I understand that. I'm not doing this to be a bad person. I'm doing this to to try to help them. And I try to put myself in their position and try to think that through. And I also try to understand that I don't know what their position is too. I go into these situations knowing that I do not know where they're at. So that's an even better level of understanding there, that I understand that I am not in their shoes and I don't know what it's like to stand in their shoes. So I try and I ask enough questions, and sometimes they just yell at me for asking too many questions, but that's fine. They come around, and sometimes they'll say, I'm sorry, I'm just frustrated, and I get that. So that's why I'm here.
And I try to be really direct with the parents. Like if it's clear that the parent is not able to provide a safe and stable home, I will really like sit down with that parent just one-on-one, and I'll talk to them about it and say, what do you want for your child, and how can we get that, and how can we help? Because right now your child's really safe, and I'm looking at where you are, and you don't have a place to live yet, or you're still fighting with your ex, and it's upsetting to the child. Like what do you want? And I had one of my early cases. I remember I had this mom who was she was using drugs, and she didn't have a place to live, and she was insisting that she wanted her child. And I remember having a conversation with her saying, why? This is about you wanting your child. This isn't about you thinking about what's best for your child. Do you really want your child going around in the car with you while you're fleeing from your boyfriend who just beat you? And I was really direct, and I'm telling that story because she heard me for whatever reason, and we placed the child with the child's grandmother, and the mom got help, and eventually she found a battered women's shelter, and then I advocated for the child to go with her. And it's been 15 years, and I'm still in touch with that mom, and the child has her own children. So it's very meaningful. Remember how important the parent-child relationship is. No matter what you're seeing that may look like parental custody is detriment, remember that anything we can do to protect that relationship, even to shield the child from seeing how unwell their parent is at a particular time, is going to be helpful, because the parent-child relationship is sacred under all circumstances. And I think that's it.
Yeah, you get to be the voice. You get to be it. And sometimes, so one of the things that I like to tell my clients also, I've got one kid right now. He's really mad at his mom, and I told him it's all right to be mad, because so many people tell him, no, you need to forgive her. Like, kid, no, you're going through so much. It's all right to be angry right now. You need to talk to somebody about getting over this anger, but I understand where you're at, and but you're gonna have to work through this stuff. And he's a teenager, and because it's been bad stuff, and so telling him it's going to be okay, it's not. I'm not like the toothfairy. It's not necessarily going to be okay for him. He's going to need some help, and somebody telling him that, it's like, ooh, that it's really helpful for an adult to say stuff like that. And that's, I think, the essence of advocacy, though, is being in there and getting to know these kids and really making a good impact in their lives. And now I've shown up at schools. I've been told to leave schools because like, who are you? An attorney showing up here? This is odd. Are you going to sue us? Like, no, I just want to talk to my clients. I'm like, you can't talk to a kid here. And then a lot of schools are like, yeah, sure. It depends on where you're at. And I like schools because they're a neutral ground.
Yeah.
It's a good place to talk to them. And but not all schools like that. But it depends on where you're at. There's good and bad. And Okay, and
When you get appointed, look at your order. You can talk to the schools, you can talk to the therapists, you can talk to the doctors. Use
and I
those
think we
powers.
are out of time right now, Lara. So I want
Well
to
done.
thank. Oh,
That's
and
fine.
so, yeah, just as a reminder that if you are interested, the information is here. It's going to be in your packet as well, that the conflict program at conflictprogram.org is a great place to start. Call us on it, 925-229-4410 for more information, or email Lara or myself. We're available anywhere on the web. The Googles, great place to find us. But
Thank you all for attending. We appreciate you. And I love this work and I hope you do too.
same here.